Good afternoon. My name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today, we are going to discuss with the labor attorney Jung Bong-soo about the interesting article that was published today by Daily Labor Daily, and which is regarding the advance notice of dismissal. So, could you explain the story first, the background, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor. Today I'd like to introduce one interesting labor case printed on this daily, Labor Daily. So that case is a hairdresser, hair designer was fired after working 1 month. Then employer didn't inform this employee 1 month in advance. So employee took legal action for not receiving 1 month additional pay. So the prosecution office charged 1 million won for this employer who didn't pay dismissal allowance. So then the employee appealed the case. Then finally Supreme Court ruled this hair designer is employee. So employee is entitled to 30 days ordinary wage for dismissal allowance. So that was the court ruling. Yeah.
So in this case, she was not a full-time employee, is that right?
Yes.
It's a part-time?
Yeah, the main issue is hair designer, whether hair designer is employee or not. So if hair designer is freelancer, like employee doesn't pay any dismissal allowance, but the hair designer is employee who can be applicable to the Labor Standard Act. Employee must pay 30 days the dismissal allowance, or employer should inform the dismissal 30 days in advance. So this employer reject to pay 30 days ordinary wage for as a dismissal allowance. So the prosecution office charged the penalty for a penalty 1 million won for this violation. Yeah.
So I understand that this case was occurred in 2019, and there was some amendment to the Labor Standard Act. So does that mean that this case was based on the court ruling was based on the amended Labor Standard Act?
Yeah, actually, yeah, that's a good point. Now, according to Article 26, employee should inform 30 days advance notice for dismissal if they decide to dismiss this employee. If they fail to dismiss, inform 30 days early notice, then they must pay 30 days notice, 30 days dismissal allowance. So this law, some exception for this early notice is the law was changed as of January 15, 2019. So exception is those who join the company within 3 months, they are exempt from early notice. But before the revision of this law, company should inform any employee 30 days in advance, or they pay 30 days non-notice allowance. So this case is happened just before revision of this exceptional notice case in the Labor Standard Act.
So if the employer does not follow or act accordingly, I understand that there is a heavy punishment. So could you explain what kind of punishment?
So this case, employer treated this hair designer as a freelancer, not the employee. But because of that, employee didn't pay the dismissal allowance, so the employer received 1 million penalty for not following. So when employer neglect to follow 30 days early notice or 30 days ordinary wage, so in that case there are big punishment. Then employee violate this Article 26 of Labor Standard Act. So employer will be charged 20 million won or less, or so 2 years imprisonment. So this the provision for early notice has a very severe punishment clause. Yeah.
So this court ruling, I think it will give a strong alert to the employer who will not give enough notice to the employee. So do you have additional comment to make?
Yeah, the main issue was whether this the hair designer is employee or not. So court thought like the how to pay wage is very important to determine whether the person is employee or freelance. So in order to be a employee, according to the Article 2 of the Labor Standard, the definition of wage is like this: employees, those who provide labor service under employers' the supervision in return for the providing labor service. So maybe okay, let me repeat again. So employee means those who provide labor service in order to make money, in order to get wages in the workplace. So that is definition. So in this definition can contain two things, like employee should work in the workplace, that means in the certain company. Also employee should receive wage in return for their labor services. So whether the person receive wage or the income is very important. This hair designer supposed to receive fixed income for the first 3 months. Then after that, after 3 months, the hair designer was supposed to receive the percentage of his contribution, like the supporting the customer, then receive some commission, then commission will be divided 60 to 40%. Then in this case it's like a business partner. But if the hair designer received the fixed amount of money, then it is more like employee. So Supreme Court ruled this hair designer received also promised to receive a certain amount of money for 30 months period. So this hair designer was fired in the first month. So Supreme Court ruled this hair designer is employee who received the fixed salaries. So they regarded this hair designer as an employee. Yeah.
I see. Very interesting article. Thank you very much for your comment.
Okay. Thank you for watching. Bye bye.